Welcome to Case by Case. This is a podcast brought to you by Calum, Cheyne and Luke Zadkovich from FZ. How are you, Calum?
I'm very good, Luke. How are you doing?
Very, very good. I've got to say, I'm super excited today, Calum. I know I say this almost every single episode we do, but truly am excited today. We've got Oliver Caplin KC on the pod with us. Welcome, Oliver.
Hi, guys. Thanks for having me on the podcast.
Pleasure. Absolute pleasure. And a really interesting case too, which Oliver was the lead counsel for the defendant on. And I'm really interested, Oliver, to talk this one through with you, because if there's ever a case that you're involved in, you know so much more about it than the judgment kind of suggests. So I'm excited to hear this one from your perspective. Obviously, you'll know all the details intimately, but it is a fascinating case, really interesting issues around anti-anti-suit injunctions, principles of comity, sub-bailment on terms. It's all great stuff for the kind of geek in me, and I'm looking forward to talking it all through with you.
Great. Well, I'm looking forward to trying to unpack it. It was a really interesting case. It was one of those cases that had so many interesting issues in it. You just didn't really have time to get through all of them in one day of court time. They're always the hardest cases. But in any event, we got a very interesting judgment out of it. So I agree.
Yeah, a really interesting judgment. And the way the judgment reads, kind of a spoiler alert here, is Oliver was successful. And, well, I say successful, I think in practical terms, successful. But strictly, this was kind of one of three potential options. Interested to hear if there's a kind of footnote to this case of what happened next. But Oliver was certainly, by all practical purposes, the successful end of this one. It's interesting to read the judgment because it kind of shapes up as though it's going a certain direction, but then obviously kind of comes back in your direction towards the end with the principles of comity and the general discretion of the court. And it's a salient reminder that a lot of these remedies are equitable and that there is a huge amount of discretion that the court can exercise when granting these kind of the sort of interim relief which was applied for here. And I was interested in reading it, through that lens as to whether when you were preparing for this case, you kind of had a sense that was going to be the strongest argument for you. And the kind of going in on the discretionary principles was going to be the likely roadmap to a successful outcome. Or whether it was kind of, almost whether you were hoping to get through on one of or expecting to get through on maybe the contractual principles and leaving the discretion as a third option.
Well, that's an interesting way of looking at it. I think one of the most interesting aspects to anti-suit injunctions, particularly contractual basis anti-suit injunctions, where someone's saying there's been a breach of a jurisdiction clause or an arbitration agreement, is that although obviously it remains a discretionary remedy, people genuinely operate on the basis that, well, if there's a breach of the jurisdiction clause or the arbitration agreement, you're going to get your anti-suit. And a lot of the time that is true because the case law suggests the English court shouldn't be diffident, in the words of Lord Justice Millett in the Angelic Grace, probably the leading pivot case in this area from 1995 when the new approach to breach of contract anti-suits began. He says, well, you shouldn't be diffident about granting anti-suits if there's a breach of contract, and goes on to say comity isn't a restraining factor usually in those scenarios. So when you approach these cases normally, you'd think, well, not going to be much point in running a comity argument because it's not going to get me anywhere. But then there are, as so often happens in our line of work, there are these subset of cases where the usual rules don't apply because it's unusual, and it's then that you need to put your thinking cap on and go back to look at how the principles really are delineated and why they are as they are, to try and shoehorn your case into, I suppose, what you might think of as an exception to the general rule or an actual reason why the court shouldn't exercise a discretion it really will 9 times out of 10 exercise. And they're the most interesting cases after a while when you've done 50 anti-suits, that are just routine. These are the ones that really spark your interest.
Yeah, they're the ones for interesting reading and for a good discussion on a podcast, I dare say. And I had a few kind of similar thoughts as I read through Calum as well. There are a number of kind of procedural steps in this case, which we'll go through in a moment, that I think are worth pausing on. And yeah, very interested to see that committee came through so strongly in the exercise of the judge's discretion here. Just before we get into the facts of the case, I thought I'd give a little intro. Oliver is one of the leading KCs at 20 Essex Street and in the market. We're delighted to have him on board. I just wanted to open up, Oliver, and say, look, what areas of the law do you tend to focus on for our listeners?
Sure. I do probably in equal shares a mixture of commodities, dry shipping and marine insurance, and particularly war risks insurance. It changes year to year exactly what proportion they're in, but those are, I'd say, my three core areas, and then a few general commercial bits and pieces around the edges. But this year it's been a lot of war risks insurance for obvious reasons with what's going on.
Not a bad time to be a war risks lawyer.
No, it is the new edition of Miller's Marine War Risks Insurance, and that was in 2020 when there really hadn't been any global conflicts that significantly disrupted commercial shipping for a long time, maybe since the Iran-Iraq War. And then suddenly since then there's been Russia and Ukraine and now the Red Sea. So although you write a book knowing that you would get busy if something happened in the world to create conflict, you don't really expect when you're writing a book that those sorts of conflicts would develop. But you're right, because they have. There has been a lot of work in that area.
Yeah, we've certainly found that as well, that, there have been almost whole practice areas kind of build up over the last few years, depending on what's been happening in the world. And yes, we'll have a specialty in a subset that we know well, and then something else is happening in the world that just balloons the practice. And so, yeah, we've certainly seen that too at our end on the solicitor side of things. So for those that don't know, this case is the case of Euronav Shipping and Black Swan Petroleum. It is a decision of the High Court in England and Wales. We were in the commercial court here, and it is a decision of Judge Caplin KC, sitting as a judge of the High Court. For our citation lovers, this citation is 2024 EWHC 896 Comm, and it was heard in March 2024. And the decision was given on the 26th of April, 2024. So yes, where to start, gentlemen? Where to start? Should we kind of maybe track through some of the facts of this case first? I think there are a few kind of legal concepts that we'll want to unpack as we go through, like what is a sub-bailment on terms? I think some of our listeners will know what that is off the top of their head. Others may not. So we might want to touch on that at some point. But I think if we kind of start at the procedural facts here and kind of work through what's happened, it's a good place to start.
Yeah. Well, do you want to do that, Calum? Or
I was just about to say that you're probably one of the best people in the world to talk through the facts of this case. So I'm very happy to have a go, but I think probably our listeners would benefit from your exposition of the facts rather than mine.
Okay, sure. Well, maybe we'll do it in stages because there are quite a lot of facts and they're quite interesting and they give rise to interesting thoughts at each stage. But just taking a step back, the case was an application by Euronav, the claimant, for anti-arbitration injunction, which takes a second to get your head around. The more antis before the word injunction, the more of a headache it is in this area. You can get anti-anti-anti injunctions, which Tom Raphael KC and Chambers used to call AAAs, which I thought was quite good. But this only had two, so it's not a AAA. But although it's an anti-anti-arbitration injunction, it's a form of anti-suit injunction in the sense that it's an injunction trying to stop the other party from doing something in a foreign forum. And the reason it was an anti-arbitration injunction is that my clients, Black Swan, had in the High Court of Malaysia obtained their own injunction, or were about to obtain their own injunction, to restrain Euronav from proceeding with a London-seated arbitration, an LMAA arbitration. So Euronav wanted to stop BSP from stopping the arbitration effectively. It's a bit like a triangle, slightly weird love triangle in the law, if you will, between all those different competing forums. And
I might use that one, Oliver.
Yeah.
I've not heard the competing forums described as a love triangle.
No, I don't think I've done it before taking silk, but that's one of the great benefits. It gives you latitude to start using dodgy analogies that you can't, as a commercial court, get ready. Phase two. But it is a sort of weird triangle between those different competing forums, and in these multi-jurisdictional or cross-border disputes, it takes a while to sort of get your head around how all the different parts fit together. And like so many of these cases, the real issue at the core of it was parties disagreeing about where the best forum for the prosecution of their claims or defences would be, and ultimately procedural jostling to try and get the claims heard in the right way or the right forum or in the right sequence. And that's something that the judge was alive to and actually had something to say about in the end, in the exercise of his discretion. So we may come back to talk about that because it's quite interesting. But he wasn't that pleased with the way things had been done procedurally, essentially. And that was a factor that counted against the grant of the injunction. But that's the basic situation.
Sorry to interrupt. We had Euronav pushing for London arbitration, and we had Black Swan pushing for the courts in Malaysia. That's the kind of tension that we've got going on here, right?
Yeah, exactly. And then the reason why this all happened is that Euronav operated a tanker called the Oceana in Malaysian waters, and it was willing to use it as floating storage. And Black Swan had a cargo of crude oil that it wanted stored, and Black Swan contracted with another company called Silk Strait under a storage agreement for the storage of its crude oil. And Silk Straits then contracts with Euronav directly for the same thing, for the storage of effectively Black Swan's oil. And so there's a chain of contracts, and that's what eventually gives rise to the bailment issues and the sub-bailment issue. There's three links in the chain, but no direct contractual relationship between Black Swan and Euronav, which is an interesting facet of the case when you're thinking about Euronav asking for a breach of contract anti-suit when there's no direct contractual relationship between. That's where you get the bailment on terms coming through, because that's how Euronav get at the arbitration agreement and hook Black Swan into it. But we'll come back to that when we perhaps a bit later on. But anyway, that's the contractual structure. And then the cargo...
Just pausing there, Oliver, what is a bailment on terms? What are we talking about there?
When you, as the owner of goods, give your goods to somebody else to look after, the law will create a relationship of bailment between those two parties, where you as the party giving your goods to somebody else to look after are the bailor, and the party receiving your property is the bailee. And in the absence of a contract between you, the law will impose some obligations on you to look after the property that's in your possession, care for it, for want of a better word, until the owner wants it back. That can exist outside of a contract. But where you have contracts in play, it's often said that something called a bailment on terms arises, which is where the bailment isn't just at large. The terms on which the receiving party has taken possession or custody of the goods are regulated by the terms of a contract in any event, or at least in some respect. So you see it sometimes in the bill of lading context as well, bailment on terms. So you can't escape the terms of a bill of lading if one is in the matrix. So what Euronav were effectively saying here is, when BSP gave the cargo to Silk Straits, who passed it on technically, figuratively, to Euronav, a relationship of bailment was created at each stage. Head bailment between BSP and Silk Straits, and a sub-bailment between Silk Straits and Euronav. But the terms on which Euronav agreed to take BSP's cargo were not at large, the terms of that bailment, if that relationship came into being, but they were to be regulated by the terms of the storage contract between Euronav and Silk Straits. And in that contract, Euronav said there was a London arbitration agreement. So they said, even though we don't have a contractual relationship with you, BSP, we have an arbitration agreement with Silk Straits, and we only agreed to take your cargo on the basis that we could rely on the terms of our contract with Silk Straits as against you. And that includes an arbitration agreement, so that's why you can't sue us in Malaysia, is basically their case narrative. And the judge held that was, they had an arguable case on that at this early stage. It's not finally decided, it's decided in an interim way. And the judge decided there was a high degree of probability that Euronav could rely on that arbitration agreement as against BSP. And if you think about that, that's quite a powerful situation. There's no direct contractual relationship between the parties, but you can still enforce an arbitration agreement to which BSP never signed up, and it would say never saw, as against it, fettering its ability to sue where it otherwise might be able to. And of course, if that's what the law provides, that's what the law provides, and it's not an unfamiliar way of looking at things in the world of anti-suits. You have things like quasi-contractual anti-suits where there's no direct contractual relationship, but still a right to enforce the jurisdiction clause. But they're still, I would say, on the periphery of the world of anti-suits, and conceptually, there can be quite difficult cases to reason through.
This concept of express or implied consent to the terms of the sub-bailment, which was a kind of a focus of debate, I think, in the hearing, where you were obviously arguing for BSP that there was not that express or implied consent, and Euronav were arguing that there must have been because of the way the contractual matrix was formed. But it is interesting that, as you say, you can have this non-contractual relationship of bailment, which is actually in fact on contractual terms, which mirrors contractual terms, including an arbitration agreement, and the court in this case was willing to accept that there was this arbitration agreement, or there was a high chance that Euronav would be able to prove that there was a arbitration agreement in the final analysis. There's a cautionary tale there for sub-bailees, or in fact, no, for bailors. Bailment is one of these ones that I always get back to front between the bailor and the bailee, but it's the bailor that has to worry that they're stuck with terms that the sub-bailee and the bailee are have agreed between the two of them.
Yeah, so you've got to really pay careful attention to what's going on in and around the negotiation of your relationship as a potential head bailor with the party you're contracting with, and look for signs in the documents you're receiving that there may be other contracts to which your counterparty is involved in. And if you're being given information about that contractual structure and you don't oppose it or challenge it, then you may ultimately be fixed with a whole set of terms that you may not have actually read. And so in this case, a BSP, a party that had nothing to do with Euronav directly and no other links to this jurisdiction, has been determined by the court at this stage to be bound by a London arbitration agreement, when in its contract with Silk Straits, from recollection, it had a Singapore arbitration agreement and a Singapore law clause. So it might have entered into its transactions thinking that the centre of gravity of its dealings were, at least in Asia, not in London, yet it finds itself before the English commercial court. And that can sometimes be very difficult for parties in BSP's position to understand and appreciate when that's the advice English lawyers give them about the situation they're in.
What was it specifically that the judge said was sufficient to trigger the sub-bailment being on the terms of the agreement between Silk Straits and Euronav, even though that's an agreement which your client had never seen?
So the slightly multifactorial, but difficult to know what was in the judge's mind and what was his key factor. But there was a debate was said that BSP knew that Silk Straits was contracting with it as a head charterer, head owner, I think was the phrase. BSP knew that there was another party, there was a head owner in the matrix somewhere, and that wasn't Silk Straits. And so it was said, I think the logic was from that, BSP would have understood that the actual party taking custody of the property was not going to be Silk Straits. There was someone else up the chain, and it must have known, therefore, that there would be a contract between Silk Straits and Euronav, and therefore there's implied consent, or I suppose, implied consent, because there was certainly no express consent. The judge found that there was implied consent to the bailment on terms going ahead, or I suppose some sort of ratification or authorization, given that knowing that structure existed, BSP didn't object to it. And that was how the judge got there. I think orthodox law, looking at the leading case here, the Pioneer Container, which says if you're going to have a bailment on terms, the head bailor, or sub-bailment on terms, the head bailor needs to have expressly or impliedly consented to those terms being applicable, or has apparently authorised them, even if they haven't seen them. So you've got to be really careful, I think, as a bailor, if there are things swirling around in the matrix or in the correspondence between you and your direct counterparty that you're not picking up and reading and thinking through the consequences of, you can get your fingers down the line.
Yeah, it's. I suppose what jumped out to me there is it's not a particularly high bar to show that the terms have been incorporated into the sub-bailment. Certainly, it's a lower bar than expressing any kind of agreement. But even the implicit consent to the terms of the arrangement that you haven't seen is quite a low bar. It's just in this case, it seems like it's just the awareness of the combination of awareness of the likely existence of those terms, coupled with not putting your hand up and saying, hey, I want to see those terms. I need to understand what's going on, and then objecting to them.
Yeah, I think you're right to hone in on this, Calum, because, I could imagine other jurisdictions around the world just, putting on an arbitration practitioner's kind of hat, having some difficulty with that. And then turning to the national court system to get anti-suit injunctions enforcing that arbitration, that awareness of the arbitration agreement. And of course, I understand how it stacks up here and I can follow it through, but I'm not sure it would be a universal approach across all national courts to that kind of question.
I agree. And it's not an uncommon feeling of parties on the receiving end of an anti-suit like this and the quasi-contractual ones to really be scratching their heads as to how they've ended up here. But I suppose it's our job to try and educate our clients who are dealing in this sphere that these are risks that they face.
But what's interesting about this case is that there are risks at different phases of the dispute. This was perhaps a risk identified at the formation stage, and perhaps not, interjecting if they wish to about becoming bound to this arbitration agreement on a sub-bailment basis. But then there are other risks, and that's, if proceedings are brought in national courts elsewhere, such as in Malaysia, how to deal with those and to tread very carefully in intervening in those court proceedings without committing yourself to the jurisdiction. So, yeah, it's quite an interesting one, that point.
There's also perhaps the biggest of all the risks, the reason that this didn't go according to plan at all, which is whose oil are you putting on someone else's ship?
Well, yes. Quite.
Yes. Yeah, that's obviously how it all blew up, because, Calum, you're referring to the fact that once the crude was on the vessel, it was alleged that the origin of the crude wasn't Iraqi, as had been said in the documents, but was in fact Iranian. And so, spinning off from that situation, ultimately, Euronav give up the cargo to the US Department of Justice. That riles BSP. You say, where's our multi-million-dollar cargo gone? Why you were meant to be the bailee for it, looking after it for us, and you've given it away. I converted it or breached. There's a breach of duty, your duty of care in relation to the cargo. And so the way things kick off procedurally is that BSP go to the Malaysian High Court and arrest the vessel. So many cases start like that. And then from there, they claim damages effectively for the conversion of the cargo, the market value of the cargo that's been lost to the US Department of Justice. They deny that it's of Iranian origin, imperative for it to be released. And they want it back, or claim damages in the alternative. And that then triggers, that action in Malaysia triggers Euronav to commence the London arbitration, the LMAA arbitration, to recover losses it says it has suffered as a result of the whole situation. And then Euronav then engage in Malaysia to resist the claim going forward there brought by BSP. And what they do what was probably you'd say is a fateful step, the judgment regards it as a fateful step, is they apply to strike out the claim in Malaysia as well as seek a stay on the basis that there's a foreign arbitration. So they do the classic stay or strike out, or either or. And the judge decides that by having applied to strike out the claim in Malaysia, they take a step on the merits. They engage on the merits, and that causes them to submit to the jurisdiction voluntarily. So it's not just a case of under caveat of a jurisdiction caveat engaging in the foreign forum, which you see all the time in these sorts of cases, and the English court will not rap you on the knuckles for doing that. It's very sensible, I think, about that sort of thing. But if you take a positive step and submit, that can be problematic. And that's what Euronav would determine by the Malaysian court to have done in a quite a long and detailed judgment. And that then opens up the opportunity for BSP to piggyback on that decision and obtain their injunction to restrain the London arbitration, because they say, as a matter of Malaysian law, it's now vexatious or oppressive of you to pursue the arbitration in London at the same time as you're engaging on the merits in Malaysia. You're interfering with the Malaysian court's processes by having your cake and eating it in both jurisdictions, essentially. Although that's not the way Euronav would see what they were doing. That's the basis essentially on which BSP got its injunction, because the Malaysian court, having been now seized with, on the merits, the question of BSP's claim in relation to the cargo in Malaysia, decided it would be vexatious for that same issue to be litigated elsewhere, given BSP had been found to have voluntarily engaged with it.
Significantly, this is a finding of the Malaysian court that Euronav has engaged with the Malaysian process and therefore submitted to the jurisdiction rather than a finding of the English court that the engagement in the Malaysian proceedings is disqualifying of the claim for an anti-suit.
Yeah, I mean, they're connected in that voluntary submission in the foreign forum is a factor weighing against the grant of an anti-suit. It's one of the discretionary factors. But within that, the English court will always look carefully at what's happened in the foreign forum. So if what's happened in the foreign forum is a technical submission, entirely inadvertent and applying English law to the situation, no one, in a country mile would say you were submitting to the jurisdiction of the English court by doing something like that, then there might be some sympathy and it might not be regarded, the voluntary submission might not be regarded as being an inhibitor to the anti-suit in London. But if what you do in the foreign jurisdiction on any objective view under English law would be sufficient to submit to the jurisdiction here, or close enough, then it's taken much more seriously and it's more likely to be a factor that can undo your anti-suit. And applying to strike out on the merits is something that in English law would recognise as going beyond merely challenging jurisdiction or seeking a stay under Section 9 of the Arbitration Act or what have you. So that's why I think it played a prominent part in the judge's decision-making.
Yeah, I think that's right. I think that's kind of the read between the lines point through this decision is that the English court had real difficulty with the step that Euronav had taken in Malaysia in seeking to strike out those proceedings. Now, we should make clear that decision has been appealed in Malaysia and is under appeal. So that appeal was pending at the time of this decision, at least, of the English court. But I think you're right. I think that the English court was looking at this and saying, well, it wasn't just a technical jurisdictional challenge under caveat, all positions reserved. There is, on its face, at least, if not further than that, a further step that was taken there by Euronav, which was a real difficult point for them when they're going then to the English court to explain what has happened procedurally and seek the English court's assistance in upholding the London arbitration.
Yeah, you're right. And voluntary submission is a particularly difficult one because it's heavily interrelated with comity, which is the other huge elephant in the room here. And in the right circumstance, a very powerful restraining factor on the English court's approach to anti-suits, the extraterritorial effect of an anti-suit and the collateral interference it has with a foreign court. The dogma is that an anti-suit, as you know, doesn't interfere directly with a foreign court. The English court isn't telling the foreign court what to do. It's telling the respondent to stop doing something in the foreign jurisdiction. But although that's the dogma, the practical reality is you are interfering, at least passively or indirectly, with the procedures in a foreign court. And that's why comity is a restraining factor in this area, and comity being the respect, in this context, mutual respect between different systems of law, the idea that different countries can do things differently and that, if there's a reason for proceedings going ahead in a foreign jurisdiction, they should be allowed to go ahead without interference, simply because we do things differently here or they do things differently in their jurisdiction. But when you begin to engage in a foreign jurisdiction and involve yourself more heavily in that foreign court's procedures, take up the court time, spend money, exclude other parties in that foreign jurisdiction from using the court because you're engaging there, the English court becomes more and more reluctant to do something which is going to create this indirect interference. And one of the high points is where you have a voluntary submission, because there, you really are engaging in the foreign court's systems. And so it's more galling, in a sense, for the English court to then reach out with an anti-suit and say everybody should stop. That's why delay also is such an important factor here. Delay is really, in my view, an expression, again, of comity, because the longer a case goes on in the foreign jurisdiction, the further involved the court is out there. And so the more damaging it is to comity when the English court's asked to reach out with an anti-suit. It's very different if you've just exchanged pleadings in the foreign court to when you're 2 weeks away from a trial or a hearing. And that's why delay in this case and generally can scupper an anti-suit very seriously.
And the delays were quite long here. In a way, usually the context to anti-suit relief is one of particular urgency and real heightened urgency when someone has an anti-suit against you and you want to get an anti-suit, or occasionally even you're trying to get in with the anti-suit in the process of what is usually an urgent application in a foreign court. So usually the anti-suit is kind of a paradigm case for real urgency. Whereas here it's kind of one of the other points that jumped out to me about this case is yes, it's urgent. Yes, things are moving very fast, but it's not that kind of complete pedal to the metal anti-suit that you might be used to. There was actually quite a long time between the anti-suit application in Malaysia. There's quite a long time between the various procedural steps in Malaysia and the anti-suit being brought here.
You're right. But I think it's important with delay to always think in this area about relative delay or delay in context. So you're not just looking at absolute delay, in that you could have a case where you don't come to the English court for 6 months after proceedings in a foreign jurisdiction are commenced, but nothing's happened in that time. And there are reasons why you didn't come to the court straight away. And that might not necessarily defeat your claim for an anti-suit. Whereas in this case, the relevant delay, I would say, was about a month between the issue of the application for the anti-arbitration injunction by BSP in Malaysia and Euronav coming to the London court. But in that month, Euronav further engaged with the applications in Malaysia and got right up to about 3 or 4 days before the hearing of the anti-arbitration injunction in Malaysia was due to take place. So evidence had been exchanged, a judge had been allocated, lawyers had been instructed and put in written submissions. So when you're looking at what happened in that 1 month, this is why comity is so important. It's delay, but looking at what effect that delay would have on comity ultimately. And because so much had happened in Malaysia, it would be such an interference with comity to put a stop to the hearing of that application at the 11th hour, even though it had only been a month. That the delay is a strong relevant factor in the exercise of the court's discretion. So yes, delay is important, but I would always say the way I always approach it is, well, let's look beyond the numbers and see what's actually been going on and whether this is relevant delay or delay that you might need to explain to the judge, but that shouldn't, on balance, be the end of the anti-suit.
And I think, as you say here, the delay was relevant because the delay is part of the submission to the jurisdiction, and part of what goes to comity is that all these things end up bundled together. As I suppose is sometimes often the case with any application of discretion, and you have discretionary principles, they usually kind of drive at the same principle of whether or not something is right to be granted. And I suppose one of the broader questions I had was whether there was a strong sense that Malaysia was a good jurisdiction for your client, or whether it was more that they were just invested in that process and they didn't want to have to undergo a second process in London.
I don't know the answer to that. And the case is ongoing, so I have to think what I should say. I mean, I think the vessel was in Malaysian waters when it was arrested. It seems to me that's why everybody was in Malaysia, because that's where the vessel was located and that's where the Admiralty jurisdiction was to effect the arrest. And the substantive claim was commenced as a result of that, in the same forum.
And it's not uncommon, I think, for the arresting court to take jurisdiction over the kind of non-arrest issues that relate to the arrest.
No, again, in the anti-suit case law, security proceedings, or proceedings for the obtaining of security only, is not a breach, generally, of an exclusive jurisdiction clause in favour of the English High Court or an arbitration agreement. It's if you go beyond the mere seeking of security and start to try and litigate the substantive issues that you then get into difficult territory. But in this case, Euronav didn't apply for an anti-suit at that stage. And in fact, it never did apply for an anti-suit to restrain the substantive proceedings in Malaysia. It only ever applied for an anti-suit to restrain the anti-arbitration injunction. So that's an interesting quirk of the case. But as for whether what really does come out of the judgment, I think, is the judge's respect for the Malaysian courts and the sophistication of the judgments that were being delivered and the procedures and processes that were being employed. Because there are some regions of the world where the legal processes are not as easy to map onto the way we would do things and as easy to understand and as predictable. And you can get decisions that don't seem to reflect the facts or the submissions that are made, and they can open up their own problems and interesting areas with anti-suits. But in this case, there was no sense in which what was going on in Malaysia wasn't anything other than an absolutely appropriate application of Malaysian local law to the facts that were before them. And one of the things that chimed with the judge was that the English court has the very same sort of power to grant similar relief to the injunction that the Malaysian judge granted in, broadly speaking, similar circumstances. Because although everyone always talks about anti-suits in this jurisdiction as being based on either a breach of contract or a vexatious and oppressive basis, as if those are the only two categories of anti-suit you can get, there are actually many more. And one of them is the protection of the English court's processes and procedures, irrespective of the other two categories I just mentioned. And that's essentially what was going on in Malaysia. And so the English judge was taken by the fact, at least in part, that, well, if we were in England and the same circumstances were foisted upon me as a judge, I might grant the same sort of relief. So that's another reason in my discretion why I won't grant an anti-suit here, because nothing that's going on in Malaysia is wrong in a sort of merit sense, if you see what I mean.
Yes, in Malaysia, the court is effectively saying we have a process by which we're going to go through and make a decision on the merits of this case. We're seeing that process through. It's kind of in the works. Obviously, there's a process to go through in any court. Nothing happens overnight. But there's a risk that process is thrown off by these parallel arbitration proceedings. So the Malaysian court is then issuing an anti-suit, or its anti-arbitration order, in order to protect its own processes. And if I understand correctly, the English court is saying we might do the same.
And that's on the basis that Euronav have participated in the Malaysian court proceedings. They've submitted to that process that you're describing there, Calum, and the English courts, I think, are looking at it saying, well, had that happened over here, roles reversed, we may well have done the same. And there seems to be a logic and a process, and it doesn't expressly say this in the English judgment, but I suspect that there's some compelling reasons given in the first instance decision from the Malaysian court as to why the Malaysian court viewed that Euronav had submitted to the jurisdiction, which was compelling reading for the English court, I suppose. Again, reading between the lines a little there, but that's how it comes through to me. I don't know whether the appeal has been determined or not. I'm not asking anything beyond what we see on this judgment to you, Oliver. But maybe the appeal courts will take a different view to the first instance decision. But I think what is essentially happening here is the English court say, well, I can see why the Malaysian court has considered that Euronav submitted to that jurisdiction. And that is a factor that comes into whether the English court will then grant the anti-anti.
Yeah, and I think it demonstrates how when you get one of these cases across your desk, you've got to have a really firm grip on what's going on in every single forum at every stage. So when you're the English lawyers, you need to be questioning what the foreign lawyers are doing and looking at the submissions they're proposing to file and critiquing and asking questions about it. And conversely, you should be encouraging your foreign lawyers to be looking at the submissions you're going to be putting in England to see if you're going to cause any problems in their jurisdiction. It needs to be a really high level degree of cooperation and sort of mutual understanding about what's going on. You can't just, I don't know what happened in this case, but just as a rule of thumb, you just can't assume that what's going on in every one of the jurisdictions in play is actually right and doesn't need to be coordinated by someone or something centrally.
I completely agree. I think that's right. And we often on this podcast talk about practitioners' tips, and I think this is one of them. I know there are cases out there where, as English counsel, looking at what's happening in other parts of the world where we're trying to protect the jurisdiction of England and be able to bring an anti-suit like this one, where we say, don't do anything. You're actually better off not engaging at all. Let the foreign court do whatever it wants and we'll protect our position here. Now, there's a vessel in Malaysia, so that's a complexity here that would be a factor and why you might not just give that blanket advice here. But if you are going to participate in some way in Malaysia, it has to be done under reservation. It has to be done in a technical sense so that you're not submitting and all the rest of it. So completely agree that degree of cooperation is so important, isn't it, on these international cases when you've got multiple jurisdictions going. Okay, so where to next?
Well, I guess where we land this plane then is the decision, which is not as black and white. As I say, I think for practical purposes, it certainly feels in reading this that you can notch that up as a win. But maybe it's helpful to talk through the judge's view and the kind of three options that he gave himself and where he landed in the context of the Malaysian proceedings.
Yeah, so we ran a number of points about why the anti-suit shouldn't be granted. One of them was that there was no arbitration agreement enforced between the parties anyway, so there's no breach of contract anti-suit available, and that was on the basis that there wasn't a bailment on terms, which is how you get to the arbitration agreement and therefore the contractual basis anti-suit. That didn't succeed for the reasons we've discussed, but that's an interim decision and that may change in due course if that point's argued in the arbitration. Then we said, well, even if the arbitration agreement is in principle something to which our client is subject, what's going on in Malaysia isn't a breach because it's something that they're entitled to do under local Malaysian law and something that Euronav have effectively consented to by reason of their voluntary submission to the jurisdiction. That was quite a nuanced argument and didn't find favour with the judge. But again, may live to fight another day, because it's quite an interesting question about where the margins of exclusive jurisdiction clauses and arbitration agreements end in these sorts of circumstances. But it's probably beyond the scope of this podcast. And then finally, we argued the discretionary points. That's what won the case for us, won this round of the case at least. And the judge had 5, I think, points. It was comity front and centre. And as I've expressed earlier on the podcast, comity's weaved into a lot of the other ideas as well, but comity was the big one. And that's important, because you hear all the time comity's not a restraining factor on a breach of contract anti-suit. But the real truth of it is that it's not normally, but in unusual circumstances it can come back in and really play a significant role, as it has done in this case. So of course, don't go into every breach of contract anti-suit case thinking you can knock it over with a comity argument, but that doesn't mean to say you shouldn't be thinking about it every time you see a case, to ask yourself, well, is this one of those cases where actually it has come back in through the back door almost and become relevant again because of the conduct of the applicant seeking the anti-suit? And then the judge was also concerned about the risk of duplicative proceedings, which is an interesting one. He was very aware, when you read his judgment, that if he did grant an anti-suit, there was a risk that, because all he would be doing is restraining, he would be issuing an anti-suit that would stop the restraint of the arbitration in London, but no attempt had been made to restrain the main claim in Malaysia. So the effect of him granting the anti-anti-arbitration injunction would be that both the London arbitration and the claim in Malaysia would proceed in parallel. So it's a slightly odd situation. He was concerned to not grant an order that would cause duplicative proceedings to be the way forward. Although in the case law for anti-suits, the risk of duplicative proceedings is not in itself something that justifies an anti-suit. It's not vexatious or oppressive usually to have duplicative litigation. The judge clearly was of the view that as part of his overall discretion, he shouldn't take a step unless he was compelled to that would necessarily lead to a rush to judgment, which is the thing people always shy away from.
Just pausing on this point, it would have been possible for Euronav to have sought to restrain the substantive proceedings in Malaysia as well. Is the court here expressing a view that, more should have been sought in the English application, and because it hadn't been, that was, a discretionary factor that was weighing into this?
I think the reality was that relief hadn't been sought, so it wasn't a relevant consideration. That because it hadn't been sought, there was no attempt to restrain the Malaysian proceedings in themselves. All that was sought was to stop the injunction restraining the London arbitration. It just was a reality that if that injunction was taken out of effect, both the arbitration and the Malaysian claim would go forward. I don't know why a different route wasn't taken. I can only speculate about that and probably should. But that's just how it panned out. The main proceedings in Malaysia, I think, were commenced in the July of the year, and this all kicked off the following March. So there was a long, you might think that the period of delay would have been fatal to any application to restrain the main proceedings 7 or 8 months on, given all that had happened in Malaysia, because the application that they were trying to restrain for the anti-arbitration injunction had only been commenced in December. That was a later, after this voluntary submission to the jurisdiction, which preceded that, I think, in September. So
I suppose what I'm saying, and sorry to interrupt, is that back in October 2023, when BSP served its statement of claim in Malaysia, at that time, Euronav could have gone to the English court at that point and brought its anti-suit. Instead, on the 26th of October, 10 days after the Malaysian statement of claim went in, Euronav applied to the High Court of Malaysia for its stay or strikeout application. And it's that step that I'm kind of highlighting, because it's not just that. I know the court doesn't say exactly this in the judgment in these express terms, but it's not just that there was the submission step taken in Malaysia, but there was also not the anti-suit brought at that time to restrain the substantive proceedings in England. And I think that implicitly factors into this duplicative point that is being exercised here in the discretion. Maybe I'm searching a little bit beyond what's here, but I think there's a link there.
Yeah, it's a sort of unspoken procedural quirk of the case that route wasn't taken. I suppose you never know what might have happened in different circumstances. But yeah, so the judge wasn't keen on doing something that would lead to duplicative proceedings. One of the other interesting factors I mentioned right at the beginning about that is that BSP had applied in the arbitration for a preliminary issue on jurisdiction about all of the same questions about whether there was an arbitration agreement, whether there was a bailment on terms. And Euronav had opposed that and said, we don't want a preliminary, we want it heard with the trial. And the judge, reading between the lines of the judge's comments about that he wasn't that keen on the position Euronav had taken there. That forms one of his discretionary reasons against the grant of the anti-suit, because had they agreed to the jurisdiction challenge in the arbitration being heard as a preliminary issue, that may well have disposed of everything much more cleanly and quickly, one way or the other, for everybody. And it was, in a sense, that decision by Euronav, which was accepted by the tribunal to challenge, not to allow the jurisdiction challenge to go ahead as a preliminary issue, that led to ultimately the whole procedural soup of different proceedings in different jurisdictions, rather than it potentially being resolved in one forum.
Yeah, it was one of the thought bubbles I had on this. I made an express comment about that, saying it didn't sound like the English court was terribly impressed by that approach. Now, thinking that through, I'm certainly not asking any questions about the arbitration, to you, Oliver. But, just speculating, I did wonder whether that had to do with, factual issues relating to the creation of the sub-bailment on terms, and that it's a question so heavily mixed with facts that they wanted the merits and the jurisdiction issues dealt with together. I was trying to see, why would you object to that as an approach? Because as we know from a number of other cases we've discussed on the pod, Calum, sometimes the arbitrators will make a preliminary ruling on jurisdiction that will then be subject to an appeal on a point of law, and it can go off into the courts in that way. And sometimes parties can agree to send issues off to the courts as well. And with the arbitrator's blessing, it heads off to the court to rule on these types of tricky, knotty issues. And there would have been a route, I think, to have dealt with this in a much more efficient way, arguably. There seems to be a bit of that comes through in these discretionary factors.
It's a sort of gentle encouragement from the commercial court to parties to think sensibly about procedural wrangling and the consequences it may have for cross-border litigation, and to think through the consequences of taking positions in any forum for the sort of global suite of litigation you've got on your hands, which sometimes requires a lot of careful thought to think through what the repercussions will be, what you might be forcing the other side to do to protect their interests, and whether in fact that's actually in everyone's best interests or not. And so you take maybe out of two unpalatable options, the less unpalatable option, even if it's through gritted teeth, but it's in the long term going to save you.
Yeah, you're right, because at that point, we're discussing jurisdictional issues with an opponent early on, and the idea of agreeing to send this off to the courts, for example, to rule on rather than the arbitrators. What you might go through some of those factors, and be discussing it with your client and thinking, why would we agree to this? This is the type of narrative or story that you may bring into that discussion. So, well, actually, it can lead to a lot more complication if we don't just get an early, clean ruling on which way to go with jurisdiction here. And if we want to protect the London arbitration, we want to keep it this centre of dispute over here in England, in arbitration and or with the supervision of the English courts, then let's have it dealt with here first and early. Get that locked in, so to speak. Anyway, interesting. Did you want to touch on any of the other discretionary factors before we wrap things up?
I think we spoke about them all as we were going along, actually, because there was delay, this point about resisting the decision about the jurisdiction challenge as a preliminary issue, and then this other point that the English court can do exactly what the Malaysian court was doing. Those were the key 5 factors altogether. So I think we've been through them.
Yeah, and so there were the 3 possible outcomes, Calum, you were referring to before. Either to grant the application, dismiss the application, or postpone it until a later date. And I think it's fair to say that the court decided that the best thing to do was the third of those options, to see how things play out in Malaysia in the meantime, if I've got it right.
This was quite an inventive way for the judge, trying to, I think, balance the need for finality with the need only to not create a situation where Euronav had to start from scratch again if there was a change of circumstance in Malaysia, but it actually created some confusion at consequentials. And in the end, the application was just dismissed. So it created confusion about, as everyone always gets excited about, the position on costs in the end. So
yeah, I was going to say,
I had to get through to a landing on what was actually meant by perhaps quite a novel solution from the judge to the situation he had in front of him, because normally the answer is either your application is acceded to or it's dismissed. You don't have this third way for obvious reasons. And so in the end, after discussion at consequentials, the application was dismissed, which obviously that's what we wanted, but I think that was the right way to do it, because you do need finality when you have an application like this. And if there's a material change of circumstances later on and someone wants to have another go, you have to issue another application and put new evidence in. And that's the way it's done. If you had a lot of applications sort of open on the books that had been half argued, but you could come back and pick up where you left off, I just can't see how it would practically work, although it might be a nice idea in principle.
Yeah, it's interesting. You've answered one of my questions, because I found that a little curious at the end. So I was going to lead into that, as how often do you see this third option as
well, you can tell when the judge said there are three ways I can answer this question, you're like, okay, he's going he's going for the third one.
Is that really?
Yeah. One of those where the outcome is kind of telegraphed early in the judgment. But I mean, fascinating, Oliver, talking it through with you and getting the insight from your side on the case, and kind of the understanding that you have, obviously, of this area of law, this case in particular. I really, really enjoyed that. Thank you.
You're welcome. Thanks for having me on.
Yeah, that was a real pleasure. Thank you, Oliver. Thank you for your time and for going through this with us, and for our listeners. Thanks, listeners, for staying tuned till the end. We hope that you've enjoyed this one. This had some real curly issues in it. And yeah, getting into questions of comity and sub-bailment on terms and awareness of arbitration agreements and all the rest of it. And I think, one of the big takeaways is the care that's needed in coordinating global efforts in litigation like this. So, and arbitration. So fascinating. Thanks again, Oliver, and we really appreciate it. Until next time, take care all.